Hello, I'm Rob Shields. Welcome to Settlement Lenders TV. In this segment, I will explain in detail how to complete the paperwork that must be finalized before your cash is released. If you have already been approved for a loan, it is mandatory that you watch this video before filling out the paperwork. Incorrect or incomplete paperwork will delay the disbursement of funds, so please read the documents thoroughly and pay close attention to the video. You will or have received by mail, fax, or email a 6-page document that includes an irrevocable assignment of proceeds, a promissory note, statement of disclosure, arbitration agreement, and consent of release information. Once these forms are properly filled out by you, another document called Acknowledgement of Assignment will be sent to your lawyer for their signature. Yours is not required on this document. So let's begin with the first 2 pages. That's called an Irrevocable Assignment of Proceeds, which lays out the basic terms, conditions, and expectations of the loan. Under the heading, you will see 3 boxes. The first box contains the name and address of settlement lenders. The second contains your lawyer's information, and the third contains your name and address. Please verify that that information is accurate. Essentially, the body of this document is broken down into 6 parts. The first part is the direction, which acknowledges the debt and instructs your lawyer to pay it back from the proceeds of your settlement. The direction includes your name, the amount borrowed, the type of claim, and the date of the claim. Please check this information for accuracy. This part also states that legal fees, court costs, and disbursements have priority over repayment to settlement lenders. The next part covers fees and fully discloses the annual percentage rate of the loan. The rate is 19.95% APR for the first year and 29.95% APR for subsequent years. Please check this information for accuracy. More specific information of the costs is detailed in another part of the document. The third part refers to a change of lawyers. Here, you are agreeing to let settlement lenders know if you change lawyers during the course of your claim. In Part 4, you are directing your insurance company to comply with any request for updates or information from settlement lenders with respect to your case. This includes any additional other insurance companies or agents that are assigned to your claim. Part 5 covers personal bankruptcy. Here, you are agreeing that in the event of your personal bankruptcy, the debt to settlement lenders cannot be included. This is a secure claim standing outside of the bankruptcy. In the final part, you are waiving your lawyer-client privilege with respect to information directly related to your claim. Once you understand and have read this document, you will need to put the date, the city in which you are signing it, and then sign an initial where it is indicated by the X's. The next document is headlined Promissory Note. By signing this document, you are acknowledging the debt to settlement lenders and promising to pay it back under the terms and conditions defined in the assignment of proceeds and repeated here. This document has 5 paragraphs. Paragraph 1 confirms that you are the borrower and that you promise to pay back your debt to settlement lenders. Paragraph 2 is your further promise to pay back the loan with interest at the interest rate we have agreed to. In paragraph 3, you are agreeing that you will pay back your loan with interest upon settlement of your claim or upon demand from settlement lenders after 1 year from the date of the loan. Paragraph 4 gives settlement lenders permission to give a charge or lien against any real property that you own or have interest in now or is acquired by you in the future with respect to this debt. The last line waives your right to notice if a lien is placed on your personal property. Once you have read and understand this document, you must sign, date, and initial where indicated. This must be witnessed by a person over 18 years of age. It can be a family member, friend, co-worker, etc. The witness must also print their name. The next document is headlined Statement of Disclosure. The purpose of this document is for you to fully understand and agree to all charges and conditions with respect to your loan. There are 10 points to this document. Point 1 is the amount borrowed and the date. Point 2 is the breakdown of the charges, including the administration fee and any other upfront charges connected with the loan. Point 3 confirms the actual funds that you will receive. Point 4 confirms the interest rate and the rate calculation. It also confirms the terms of repayment. Point 5 explains in detail how the interest is calculated. Point 6 means that because the interest rate is expressed in annual terms, early repayment will increase the actual interest rate charged. Point 7 confirms that in the event that your claim is unsuccessful, the full amount of the loan and interest will be forgiven by settlement lenders. Point 8 confirms that in the event of non-repayment of the loan in violation of the loan terms, that the borrower will be responsible for all charges related to collection of the debt. Point 9 clarifies that in the event that the court finds the charges excessive, you agree that the new rate, regardless of the ruling, will be set at 0.01% below the maximum permitted by law. And point 10 means that if any part of this statement of disclosure is found to be invalid, it will be removed from the disclosure and all other parts will remain in effect. Further to this, all other documentation will remain in force. These agreements are enforced in accordance with the laws of Alberta, and all disputes will be resolved through arbitration. In the final paragraph, you are confirming that you have read, understand, and agree to the terms laid out in the statement of disclosure. This document must be signed and dated where indicated. The credit grantor's signature will be filled in once we receive your signed documents. The next document is the arbitration agreement. This agreement confirms and acknowledges your right to dispute this agreement. It further confirms that you understand that any disputes over any part, terms, or costs will be resolved through binding arbitration under the laws of the province of Alberta. Once you have read and understand the arbitration agreement, it must be dated and signed where indicated with the X's. This document requires the signature and printed name of a witness over the age of 18. Settlement lenders will fill in their signatures when the documents are returned. The final document is headlined Consent to Release Information. Basically, this document gives permission to your lawyer and any other counsel acting on your behalf to disclose all and any information pertaining to your claim to settlement lenders. Further to this, you are agreeing to inform settlement lenders about any changes in your personal status, change of lawyers, or any other changes that may affect the claim and/or agreements. Once you have read and understand this document, you must date and sign it where indicated with the X's. This document also requires the signature and printed name of a witness over the age of 18. Now that you have completed the paperwork, you should return it to settlement lenders via email, courier, fax, or mail, and we'll review, confirm, and issue your cash. If you have any questions or require further assistance or information, please call us at 1-866-210-7200. Thanks for watching.
The confirmation code required by your loans officer is 8405.